بسم الله الرحمن الرحيم. الحمد لله رب العالمين والصلاة والسلام على سيد المرسلين. All praises to Allah. We send peace and salutations upon Rasulullah sallallahu alaihi wasallam. It is time for the morning message for today, and as usual, we have our Fadilat Sheikh Munier Abdoroaf, Fadilat Sheikh, with his beautiful message every Thursday, where we learn about inheritance. So important to learn about that, and he's an expert in this field. Let's welcome Fadilat Sheikh. Assalamu alaikum, Fadilat Sheikh. Ahlan wa sahlan wa marhaban.
وعليكم السلام ورحمة الله وبركاته Sheikh Samih, and shukran for having me this morning.
الله يفتح عليكم ويتقبل منكم. زادكم الله علما وتوفيقا. تفضل فضيلة الشيخ.
آمين.
بسم الله.
الله خيرا. بسم الله الرحمن الرحيم. الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين سيدنا وحبيبنا ومولانا محمد صلى الله عليه وسلم وعلى آله وصحبه أجمعين ثم أما بعد. To the respected Sheikh Samih, and to the viewers out there, I greet you in the universal greetings of love, mercy and peace. Assalamu alaikum wa rahmatullahi wa barakatuh. Yes, we're still looking at the laws of inheritance and what Allah subhanahu wa ta'ala had ordained in the Quran and via the Prophet Muhammad sallallahu alayhi wa sallam concerning what should happen to our estates once we pass away. Last week we've looked and touched on the various estate liabilities and those first class of claims that must be deducted from the estate once we passed away. Today we're going to look at something which many of us we shy away from, and that deals with instances where children were born, but however it was born basically conceived out of nikah, where the mother and the father was not married in terms of Sharia, in terms of Islamic law, when the child was conceived. Now, in terms of Islamic law, there are certain consequences that flow from this. And this looks at the intestate succession tie, where a person has a right to inherit from the estate based on the tie to the deceased. For example, the most famous ones would be a marriage tie as well as a blood tie. These are the two ties that we generally work with when distributing the estate in terms of Sharia law. Now today we'll be looking at that blood tie. Now, firstly, when looking at a child conceived out of wedlock, right, this could potentially be a disqualification, where the child is not entitled to inherit from the estate of a parent. Now, the parent that we're looking at here is only the father. As far as the mother is concerned, in terms of Islamic law, that child will always be entitled to inherit from the mother, whether or not that child was conceived in wedlock or if the child was conceived out of wedlock. We're not saying that it's allowed in terms of Islam to have an extramarital affair, to do those things that Allah subhanahu wa ta'ala had forbidden in the Quran and by the Prophet Muhammad sallallahu alayhi wa sallam. There are automatically certain legal consequences that will flow therefrom in terms of Islamic criminal law. However, we're looking at today the consequences in terms of the laws of inheritance, the laws of succession, what would apply as far as that is concerned. Now, as far as the mother is concerned, that child will inherit from his or her mother. Right? That tie has been confirmed, and because she gave birth to that child, and there is no disqualification. The issue, however, lies with the father. So, for example, when looking at the position of the mother, if a will was drafted and executed, stating therein that I leave my estate in terms of the Islamic law of succession, and I leave it up to the Muslim Judicial Council to issue an Islamic distribution certificate stating who my lawful heirs are at the time of my death. If that will was executed by the mother by a mother, all her children conceived in wedlock and out of wedlock will feature on that MJC certificate, for example. However, the position of the father, however, is a bit more tricky. Now, obviously, if the child was conceived in marriage, there would be there would be the blood tie, and there would also basically be no disqualification. All right, unless there's some other disqualification, maybe the child is of a different religion to the deceased and so forth, or the child killed the deceased. But in the absence of all of this, the mere fact that there is a blood tie, that would be sufficient for the child to inherit from the father on condition that he was conceived in wedlock. But if out of wedlock, then it becomes a bit more tricky. Now, the general rule is, if that child was conceived out of wedlock and born at least 6 months or more after the nikah, right? I'm referring now to the Islamic marriage, because some couples, they opt to have a civil marriage in terms of the Marriage Act, for example, as well as an Islamic marriage. Some of them, they perform and solemnize the civil marriage before the Islamic marriage, and others, they solemnize the civil marriage after the Islamic marriage. So there are various ways of doing this. But nonetheless, the marriage that we are looking at is the Islamic marriage, the marriage that normally takes place at the masjid with the assistance of the imam who oversees the procedure. All right. Now, if the child was born 6 months or more after the Islamic marriage, then there is a presumption that that child has been conceived in wedlock, and all normal rulings will then apply as far as that is concerned. If the father does pass away, the certificate or the Islamic distribution certificate will then feature the name of that child, because that child was born 6 months or more. So therefore, it's very important to have documentation of the nikah certificate. The birth certificate or the ID of that person will be very easy to find, but have documentation as far as this is concerned. Now, the next question is, what happens if the child was conceived 6 months or within 6 months or less than 6 months after the nikah? Then it does become problematic. In that instance, the child would be disqualified. Now, the disqualification now means that he would not, or she would not, be entitled to inherit as a compulsory beneficiary. Right? Compulsory beneficiary, meaning in terms of ayah number 11 of Surah An-Nisa, where Allah says, يُوصِيكُمُ اللَّهُ فِي أَوْلَادِكُمْ لِلذَّكَرِ مِثْلُ حَظِّ الْأُنثَيَيْنِ. Right? When Allah had ordained concerning the inheritance of the children, right, with a male, double the share of the female, right? That being another question. But the mere fact we're looking at here is what the person is entitled to, right, as far as a blood tie is concerned. That parent, obviously after having made tawbah and all of that, there are certain possibilities. If the father, in this instance, he makes a wasiyah, he can make a bequest, that I bequeath by way of a wasiyah up to a maximum of 1/3 is within his power to do so in favor of that child. Because Allah subhanahu wa ta'ala says in the Quran, min ba'di wasiyatin yusa biha aw dayn, that the inheritance that we refer to for the sons and the daughters and so forth are only after the wasiyah has been executed. So if you are disqualified from inheriting as a compulsory beneficiary, then you would qualify to inherit as an optional beneficiary, that is via the wasiyah. And this provision, as found within the Islamic law of succession or the Islamic law of inheritance, can be used in order to fix not this problem that has been created by the parties concerned. The father, in this instance, could also say that I hereby bequeath to my son or daughter that was conceived out of wedlock and born maybe within 2-3 months of the nikah, can then say that I bequeath the same amount that my other children that was conceived in wedlock would inherit, that same amount should then be inherited by my son or daughter that was conceived out of wedlock. What then happens here is that each and every one of your children will at least the males, they will inherit their share, but equally all males as well as all females will inherit their share, which is now based on the 2:1. However, the disqualified child that was conceived out of wedlock would still then inherit as if he was conceived in wedlock. However, what is important to note, even though they would inherit exactly the same share as they would have inherited had they been conceived in wedlock, the way of inheriting is, however, different. The one is inheriting by way of a wasiyah, by way of a bequest, and the other, however, is inheriting by way of the Quranic injunction as being a Quranic heir in terms of ayah number 11. What is very important to note in this regard is that that bequest made in favor of that child conceived out of wedlock may not, however, exceed 1/3, right, of the net estate. And that is now the estate after all liability claims have been deducted, the liabilities that we have referred to last week. So in this instance, let's say, for example, the person passes away, leaving behind only 2 children. His parents might have passed on, and his spouse might have passed on already. So only 2 children. The one child was conceived in wedlock, whereas the other child was conceived out of wedlock. Let's say the daughter was conceived out of wedlock, and the son was conceived in wedlock. If there is, for example, a net estate of 300,000 rand, it means that the bequest, the wasiyah, could be a maximum of 1/3, which means 100,000 rand then goes to the daughter. If he does make that bequest to the complete wasiyah, the remaining 2/3 then would go to the son. That would now be the 2:1, basically. But there's no daughter because there's only one child left that was conceived in wedlock. However, so there it works out perfectly because it will be the Quranic injunction and the wasiyah application is one and the same. If, however, he left behind 2 sons, and the one son was conceived in wedlock, the other was out of wedlock, but not more than 6 months after the nikah was a child born. Not more than 6 months after the nikah. In that instance, again, that disqualified son can inherit a maximum of 1/3 of the wasiyah. So which means that the son, had he been conceived in wedlock, would have inherited equal shares with the other son. But now in this instance, the maximum of the 1/3 applies. So 100,000 rand goes to the son, and the 200,000 rand goes to the other son. So I hope this clarifies the issue concerning wedlock and children that are produced as a consequence of it being an extramarital affair, and what options are available after the persons, however, have made istighfar and ask Allah subhanahu wa ta'ala's forgiveness. May Allah subhanahu wa ta'ala grant us true understanding,
Ameen.
and may Allah subhanahu wa ta'ala grant us to grow from strength to strength. أقول قولي هذا والحمد لله رب العالمين. And I'll hand back to Sheikh Samih. جزاك الله خير.
Jazakallah khairan, Fadlat al-Sheikh, for this information. I ask Allah subhanahu wa ta'ala to bless you and to accept from you. Shukran jazeelan, barakallah fikum.
جزاك الله خير.
Assalamu alaikum wa rahmatullah. Alaikum assalam wa rahmatullah wa barakatuh. This was Fadlat al-Sheikh Munier Abdoroaf. Fadlat al-Sheikh, every Thursday you can join us inshallah and get to know more about inheritance and about these shari'i matters inshallah. May Allah Azza wa Jal accept. Allahumma ameen ya Rabbal Alameen. زادنا الله وإياكم علما. Allahumma ameen. We're going to be taking a short break. We'll come back after the break. Stay with us.